presided over thousands of disputes, and I have seen people lose their tempers in ways that still surprise me. But there is one case I will never forget because it began with one of the most unbelievable claims ever presented in my courtroom. A retail employee insisted she had banned a judge from entering the very store where she worked. She believed she had acted with complete authority. What she did not know was that the store owner would soon testify under oath, and what happened after that changed her life in a matter of seconds. Before we go any further, make sure you have subscribed to this channel for more powerful courtroom stories like this one. And if you haven't subscribed yet, do it now. Also, comment below and tell us where you are watching this video from. Now let me take you back to where this case truly began. My name is Judge Judith Harper. During my years on the bench, I learned something that proved true again and again. Power is often misunderstood. People sometimes confuse responsibility with authority, authority with ownership, ownership with control. And when those ideas become blurred, ordinary disagreements can spiral into extraordinary consequences. The plaintiff was a woman named Karen Collins, 45 years old, confident, immaculately dressed, a department supervisor at an upscale home decor store called Heritage Living. According to her lawsuit, she had been wrongfully terminated after a confrontation involving a customer she later discovered was a sitting judge. The defendant was Heritage Living itself, represented by its owner, David Reynolds. A businessman who had built the store from a single location into a respected regional chain over nearly 3 decades, David carried himself differently from Karen. Quiet, measured, thoughtful. He answered every preliminary question directly. Karen, on the other hand, answered nearly every question with another explanation. Years on the bench teach you to notice those differences. People focused on facts usually answer the question asked. People focused on controlling the narrative often answer the question they wish had been asked. The courtroom was unusually full that morning. Several former employees sat quietly in the gallery. A handful of customers had also appeared after being subpoenaed as witnesses. That immediately told me this dispute reached far beyond one unpleasant afternoon inside a retail store. Corin began her testimony confidently. She claimed she had merely enforced store policy. She insisted the customer had been disruptive, disrespectful, armative. According to Karen, asking that customer to leave and permanently banning her from the premises was entirely justified. She spoke with complete certainty. Complete certainty can be persuasive, but experience has taught me that certainty is not evidence. Then came a detail that immediately captured my attention. Karen proudly stated that she had personally informed the customer she was never welcome in the store again. She smiled as she recalled saying it. That smile lingered for only a moment because the defense attorney asked a simple question. Ems. Collins, did you own Heritage Living? Karen looked surprised. No. Were you a corporate executive? No. Were you authorized by the owner to permanently ban customers? Karen hesitated, only briefly. But judges survive professionally by noticing brief moments. She finally answered. I believed I had that authority. Believed. Not knew, believed. That single word stayed with me because assumptions have consequences, especially when someone acts upon them. As testimony continued, I found myself increasingly curious about one person who had not yet spoken, David Reynolds, the owner, the only individual in that courtroom who could answer one crucial question. Had Karen actually possessed the authority she claimed, or had she exercised power that was never hers to begin with? What none of us yet realized was that David's testimony would reveal something Karen had desperately hoped would remain hidden. And before this trial ended, the owner would describe exactly what happened the moment he reviewed the store's security footage. It was a moment so decisive that Karen's employment ended before she even had time to gather her belongings. The second day of trial began with a courtroom that felt noticeably different. Word had spread. Former employees filled several seats in the gallery. A few regular customers quietly took places in the back row, even before testimony resumed. I sensed this case was larger than a disagreement between an employee and her employer. It was becoming a case about judgment, not judicial judgment, personal judgment. Karen Collins entered the courtroom wearing the same confidence she had displayed the previous day. She smiled briefly toward the gallery before taking her seat. David Reynolds arrived carrying a single leather portfolio. No dramatic gestures. No visible emotion, just documents. Years on the bench have taught me something remarkably simple. People who rely on evidence usually carry folders. People who rely on emotion usually carry speeches. Karen's attorney resumed direct examination. Karen insisted she had acted to protect the store. According to her, the customer had challenged store policy, questioned her authority, and refused to leave after being asked. She described herself as maintaining order, remaining professional, following procedure. Her testimony sounded polished, perhaps too polished. Then the defense began cross-examination. The attorney displayed Heritage Living's employee handbook, a document every manager was required to sign. Karen acknowledged her signature immediately. The attorney flipped through several pages before stopping at the section titled Asterisk Customer Conduct and Removal Procedures. He enlarged the policy on the courtroom screen. Everyone could read it, including the jury, including Karen. The policy was straightforward. Department supervisors could ask disruptive customers to leave for the day. Only the store owner or regional operations director could issue permanent trespass notices. The language was unmistakable. The attorney looked at Karen. Ms. Collins, were you the owner? No. Were you the regional operations director? So, under company policy, could you permanently ban a customer? Karen shifted in her chair. I believe the circumstances justified it. The attorney repeated the question. Could you? A long pause followed. Finally, Karen answered, no. That single word changed the atmosphere. I watched several jurors write notes. One looked directly at the policy again. Another circled something on a legal pad. Those reactions mattered, because jurors often place great weight on admissions made against one's own interest. Then another exhibit appeared. An internal email Karen had sent immediately after the incident. The timestamp showed it had been written less than 20 minutes after the confrontation. The attorney read aloud. I handled the situation myself. I permanently banned the customer before corporate could interfere. The courtroom became noticeably quieter. I read the sentence again silently. One phrase stood out: before corporate could interfere. Interesting. Very interesting. That wording suggested Karen already knew approval had not yet been obtained. It implied urgency, perhaps even awareness. Years of hearing testimony teach judges to pay attention not only to what people say, but why they choose particular words. Karen attempted to explain. She claimed she meant corporate would eventually agree with her decision. Perhaps not. But explanations offered months later rarely carry the same weight as words written in the moment. Then David Reynolds' attorney stood. Your Honor, the defense's next witness is Mr. David Reynolds. I looked toward the owner. He calmly rose from his chair, walked to the witness stand, took the oath without hesitation. As he settled into the witness chair, Karen's confidence changed for the first time. It was subtle. Most people probably missed it. I did not. She stopped making eye contact with him. Instead, she stared at the evidence table. Because the one person who truly knew what happened after that incident was finally about to speak. And what David revealed about the store's security footage and the phone call he received only minutes later would completely dismantle Karen's version of events. David Reynolds walked to the witness stand with the kind of composure that cannot be rehearsed. I have seen it before. People who know the facts are on their side rarely feel the need to perform. He adjusted the microphone, took a sip of water, and waited for the first question. No dramatic entrance, no attempt to impress the jury. Just quiet confidence. The defense attorney began with David's background. He had founded Heritage Living 28 years earlier with one small storefront and 2 employees. Over the years, the business had expanded into several locations across the state. Despite that growth, he maintained one personal rule. Every customer complaint involving employee misconduct came directly to his desk. That statement immediately caught my attention. Because it meant David had personally reviewed what happened on the day, Karen claimed she acted appropriately. The attorney asked the obvious question. Were you contacted about the incident? Yes. By whom? Karen. David explained that Karen had called him shortly after the confrontation. According to her description, an aggressive customer had refused to follow store policies, disrupted other shoppers, and forced her to permanently ban the individual from the premises. She reportedly assured him that everything had been handled professionally. Years on the bench have taught me never to judge a case based on the first version of events. The first story is often incomplete, sometimes unintentionally, sometimes not, the attorney continued. What did you do after receiving that phone call? David answered without hesitation. I reviewed the security footage. Those 5 words changed the atmosphere inside the courtroom. Karen lowered her eyes toward the table. The jury leaned forward. I noticed nearly every juror stop writing. They wanted to hear this, so did I. David explained that every public area inside Heritage Living was covered by high-definition security cameras, multiple angles, clear audio near the customer service counter, documented recordings. He watched the incident from beginning to end, not once. 3 times. Then the attorney asked the question everyone was waiting for. Did the footage match Karen's description? David looked directly at the jury before answering. No. Simple. Direct, powerful. The attorney asked him to explain. David described what he observed. The customer had approached the service desk carrying a receipt and a damaged lamp. She appeared calm, respectful. She simply requested either a replacement or a refund. Karen immediately questioned the customer's attitude. Within moments, the conversation became confrontational, not because of the customer, because of Karen. David testified that the customer never raised her voice, never threatened anyone, never refused lawful instructions. Instead, Karen repeatedly interrupted her before finally declaring that she was banned from returning to the store. The courtroom remained silent. Karen shifted uncomfortably in her chair. Then came another important question. Did the customer identify herself as a judge during the incident? David smiled slightly. No, that answer surprised several jurors. It surprised me as well. The attorney continued. When did you learn the customer was a judge? David replied, after I called to apologize. Interesting. Very interesting. So the decision to investigate had nothing to do with the customer's profession. It had everything to do with Karen's conduct. That distinction mattered enormously. Because justice should never depend on status. David then revealed something that immediately changed the direction of the case. After reviewing the footage, he had driven to the store personally. He didn't send a manager. He didn't schedule a meeting. He went himself. Because what he saw on those cameras convinced him immediate action was necessary. What happened when he walked through those front doors would become the most unforgettable moment of the entire trial. And Karen had absolutely no idea that several employees had witnessed every second of it. I have learned that the most revealing testimony often comes from people who have nothing to gain by exaggerating. David Reynolds struck me as exactly that kind of witness. He wasn't trying to humiliate Karen. He wasn't trying to entertain the jury. He simply answered each question with the same steady tone he had used since taking the stand. The defense attorney asked him what happened after he finished watching the security footage. David folded his hands for a moment before answering. I got in my car and drove straight to the store. The courtroom remained silent. He explained that the drive took just under 30 minutes. During that time, he replayed the footage in his mind again and again. He wasn't looking for excuses. He was looking for context. Sometimes video misses what people experience in person. But the more he reviewed it, the clearer the situation became. Karen had escalated an ordinary customer service issue into a personal confrontation. When David arrived, he didn't announce who he was there to see. Instead, he walked through the showroom like any other customer. Years of running retail stores had taught him that employees behave differently when they don't realize the owner is watching. That observation immediately resonated with me. In court, as in life, unguarded moments often reveal the most truth. David testified that he watched Karen interact with 2 customers before approaching her. According to him, she was efficient, knowledgeable, professional. Then a customer asked to use an expired promotional coupon. Karen's demeanor changed almost instantly. Her voice became sharper. Her patience disappeared. The customer looked embarrassed. Eventually, another employee quietly stepped in and resolved the issue. David made no comment. He simply observed. Then he approached the service counter. Karen smiled. She had no idea he had already watched the footage. She greeted him confidently, asked how she could help. David said he asked a single question. Karen, did you permanently ban a customer yesterday? She answered immediately. Yes. No hesitation, no uncertainty. Then she reportedly added something that echoed through my mind even as she testified months later. I showed her who's in charge. The courtroom grew noticeably quieter. That sentence revealed far more than Karen probably intended. Authority is not demonstrated by humiliation. Real authority requires restraint. The defense attorney asked David what he said next. He answered calmly. I asked who authorized the ban. Karen reportedly replied, I did. Again, no mention of company policy, no mention of seeking approval, just certainty. The attorney then displayed another exhibit, an internal operations manual. David identified it as the official handbook used to train every supervisor. One paragraph was highlighted. It stated clearly that permanent customer bans required written approval from ownership or executive management. Karen had already admitted she possessed neither. The contradiction was now impossible to ignore. I looked toward the jury. Several members were comparing the handbook with their notes. Others watched David closely. His testimony remained consistent, measured, unemotional. That consistency carries weight. Then the attorney asked the question I had been anticipating since David first took the stand. What did you do after Karen told you she had shown the customer who was in charge? David paused, not dramatically, thoughtfully. I told her I needed to speak with her in my office. Karen stared down at the defense table. She never looked at David because she knew exactly what came next. And within moments, David would describe a conversation behind that office door that would explain why Karen's employment ended before the business day was over. There are moments in a courtroom when testimony no longer feels like a disagreement over facts. It becomes an account of choices. This was one of those moments. David Reynolds sat calmly in the witness chair as the defense attorney asked him to describe what happened after he invited Karen into his office. The courtroom was silent. Even Karen's attorney stopped writing. Everyone understood that we had reached the turning point of the trial. David explained that he closed the office door and asked Karen to sit down. She remained standing, confident, almost defiant. According to David, she immediately began explaining why she believed she had protected the business. She insisted the customer had challenged her authority. She argued that strong managers sometimes had to make difficult decisions. David listened without interrupting. Years of leading employees had taught him that people often reveal more when they believe they are defending themselves. When Karen finished, David asked a single question. Did you review company policy before banning that customer? Karen answered no, then he asked another. Did you call a regional manager for approval? Again, no. Did you contact me before telling a customer they were permanently banned? No. Each answer became shorter. Each pause became longer. The jury followed every word. Then David testified that he turned his computer monitor toward Karen. On the screen was the store's security footage. The same recording he had watched 3 times the night before. He pressed play. Neither of them spoke. Karen watched herself greet the customer. She watched herself interrupt. She watched herself point toward the exit. She watched herself declare that the customer was banned from ever returning. And then she watched something she apparently hadn't realized the cameras had captured. After the customer quietly walked out of the store, Karen turned toward another employee and laughed. Then she said, "People like that need to learn who's in charge." The courtroom became perfectly still. I looked toward the jury. Several members immediately wrote notes. One juror slowly shook his head. David testified that when the video ended, he looked at Karen and asked if there was anything in the recording that had been edited. She answered no. He asked whether the footage accurately reflected what had happened. Again, she answered yes. Years on the bench have taught me that there is tremendous power in allowing people to confront their own actions. No accusations, no raised voices. Just reality. Then came the question that changed everything. The defense attorney asked, "Mr. Reynolds, why did you terminate Miss Collins?" David didn't hesitate. "I didn't terminate her because she made a mistake." The courtroom remained silent. "I terminated her because she abused authority she never had, misrepresented the incident to ownership, violated written company policy, and treated a customer with disrespect that damaged the reputation of a business my family spent 28 years building." His words carried no anger, only conviction. Then he described what happened next. He reached into his desk, removed a prepared termination notice, placed it in front of Karen, and calmly said, "Your employment ends today." Karen reportedly stared at the paper in disbelief. She asked if he was serious. David answered with one sentence. "I trust employees who admit mistakes. I cannot trust employees who invent authority." The The courtroom fell silent once more. Even Karen seemed unable to respond. As I listened, I realized this case had never truly been about one customer. It had been about responsibility, about accountability, about understanding the limits of authority. But there was still one final chapter left, because the jury had heard every witness, seen every document, watched every contradiction unfold. And now it was time for justice to deliver its answer. The final day of the trial carried a different kind of silence, not the silence of uncertainty, the silence of reflection. By then, every witness had testified, every email had been reviewed. Every policy had been examined. The security footage had been discussed from every possible angle. Nothing of significance remained hidden. The attorneys rose to deliver their closing arguments. Karen Collins' attorney argued that termination had been too severe. He acknowledged that mistakes had been made, but insisted they did not justify ending the career of an employee who had spent years with the company. It was a thoughtful argument, one that deserved careful consideration. Then David Reynolds' attorney stood. He did not spend much time talking about the customer. Instead, he focused on trust. He reminded the jury that every successful business depends on employees understanding the limits of their authority. A supervisor has responsibilities. A manager has responsibilities. An owner has responsibilities. When someone begins exercise powers they were never given, the entire foundation of trust begins to crumble. As I listened, I found myself reflecting on something I had learned after decades on the bench. Very few cases are truly about the event that appears in the lawsuit. Most are about the choices that followed. The jury retired to deliberate. The courtroom emptied into quiet conversations. Karen sat with her attorney, occasionally glancing toward David. He remained calm. He never looked back. Several hours later, the clerk informed me that the jury had reached its decision. Everyone returned. The room grew still. I looked toward the foreperson. The verdict form was handed to the clerk. Then it was read aloud. The jury found in favor of Heritage Living, and David Reynolds Karen's claim for wrongful termination was denied. The jurors concluded that the company had acted within its policies and that David had legitimate grounds to end her employment after determining she had exceeded her authority and misrepresented the incident. Karen closed her eyes for a brief moment. No protest, no dramatic reaction. Only silence. David exhaled slowly. It was the first visible emotion he had shown during the entire trial. After dismissing the jury, I addressed both parties one final time. I explained that leadership is never measured by how much authority someone claims. It is measured by how responsibly that authority is exercised. Every workplace depends on trust. Customers trust employees to treat them fairly. Owners trust managers to follow policy. Employees trust leaders to act consistently. When that trust is broken, consequences often follow. I also reminded the courtroom of something that applies far beyond retail stores. Respect cannot be demanded through intimidation. It is earned through judgment. Karen believed banning a customer proved she was in charge. Instead, it proved she misunderstood what being in charge actually meant. As the courtroom emptied, I gathered the final exhibits: the employee handbook, the internal emails, the photographs, the testimony transcripts. None of those documents raised their voices. None of them argued. They simply recorded what had happened. Years on the bench have taught me that evidence has a remarkable quality. It never becomes offended. It never becomes emotional. It simply waits to be examined. I have often thought back to David Reynolds' testimony. Not because he fired an employee. Owners make difficult personnel decisions every day. What stayed with me was the reason behind his decision. He did not fire Karen because she dealt with a difficult customer. He fired her because she assumed authority she never possessed, defended that assumption instead of correcting it, and placed her own pride above the values of the business she represents. That lesson has stayed with me ever since. Titles do not create authority. Uniforms do not create authority. Confidence does not create authority. Authority exists only where responsibility, accountability, and trust come together. The moment any one of those disappears, real authority disappears with it. And that is a truth I have seen proven in court more times than I can count.